Imagine an NGO running a school, hospitals, or orphanage with foreign funds or donations for years. Now imagine one day its license expires or get cancelled. Now tell me one thing, who will own the school buildings, the medical equipments, or the donated fund? The answer to this could change under the Foreign Contributions Regulations Amendment Bill 2026. What exactly is this bill? Why is government bringing it? And why are NGOs and legal experts calling it a controversial? Let's see it in details. But before understanding the amendment, let us first of all understand what is this FCRA all about. The Foreign Contributions Regulations Act, or FCRA, regulates how Indian NGOs, charities, educational institutions, and religious organizations receive money from foreign sources. Its main objective is to ensure that foreign funds are used legally and do not affect India's sovereignty, security, or public interest. Every organization receiving foreign donations must obtain and periodically renew an FCRA registrations. The government has introduced the FCRA Amendment Bill 2026 in the Lok Sabha, and the biggest changes that government is going to make in this act is the creation of designated authority. If an NGO's FCRA registration is cancelled, surrendered, or expires, this authority will be empowered to take over, manage, or dispose of assets created using foreign contributions. In the case of religious institutions, the bill says that the authority must preserve the religious character of the property while managing it. Besides that, the bill also introduced automatic cancellations of registration if an organization fails to apply for renewal before its 5-year validity ends, or if its renewal application is rejected. Another important change is greater personal accountability. Key office bearers such as director, trustee, or managers can now be held personally responsible for certain violations of the act. Interestingly, while the oversight becomes more stricter, the bill also reduces the maximum punishment for many offences from 5 years imprisonment to 1 year. Finally, it proposes that state police or investigating agency must obtain prior approval from the central government before initiating investigations related to FCRA matters. Supporters of the bill argue that stronger regulation is necessary to improve transparency and prevent misuse of foreign fundings. They believe that organizations handling overseas donations should be subjected to strict accountability. Second, legal experts point out that the bill does not clearly provide a statutory appealing mechanism or a mandatory hearing before refusing renewal of an FCRA certificate. Third, many civil society organizations believe that giving broader power to the executive could create operational uncertainty for charities, educational institutions, and religious organizations that depend on foreign funding for public welfare activities. However, critics have raised several concerns. First, they argue that organizations which fail to renew the registration could lose control over long-term assets such as schools, hospitals, and community centers built using foreign contributions. Therefore, the debate is not only about regulations, it is about finding the right balance between national security and the independence of the civil rights organizations. The FCRA Amendment Bill 2026 would significantly change how foreign-funded organizations operate in India. Supporters see it as a step toward greater transparency and accountability. On the other hand, critics worry that it could increase government control and make it more difficult for the genuine NGOs to function. Ultimately, the future of the bill will depend on parliamentary debate, committee scrutiny, and its form if enacted. So, what do you think? Should India tighten oversight of the foreign-funded organization, or should there be stronger mechanisms to protect the genuine NGOs? Let us know your opinion in the comment.